No one lays down the law like Car and Key. This is the Law Report on SAFM. No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report program. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, it's again time to open the lines for you to ask that particular legal question that doesn't quite fit into the other topics we discuss here on the Law Report. And I'm joined once again this evening by attorney Nicoline Skuman-Low, and she's a director of Skuman Law Inc., attorneys, conveyancers and notaries public. Nicoline, good evening. Welcome back to the show.
Thanks, as always, for having me.
Can't believe the month goes by and you're back again.
Goodness.
And if you've got any questions, we do have just a few emails to get through this evening. I think it's 3 or 4 we've got. But you can call in now in the meantime, 0892 10 2010, 0892 10 2010, and leave your name and number with my producer, and we'll call you back as soon as we're done with the emails. So just to get...
No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report program. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, it's again time to open the lines for you to ask that particular legal question that doesn't quite fit into the other topics we discuss here on the Law Report. And I'm joined once again this evening by attorney Nicoline Skuman-Low, and she's a director of Skuman Law Inc., attorneys, conveyancers and notaries public. Nicoline, good evening. Welcome back to the show.
Thanks, as always, for having me.
Can't believe the month goes by and you're back again.
Goodness.
And if you've got any questions, we do have just a few emails to get through this evening. I think it's 3 or 4 we've got. But you can call in now in the meantime, 0892 10 2010, 0892 10 2010, and leave your name and number with my producer, and we'll call you back as soon as we're done with the emails. So just to get through those, and then we'll get on to your calls.
Hold on. Wait. Listen, here's my favorite part. Yeah. Hey, slow down, bro. You're gonna kill us. Hey.
60% of South African road users who die from crashes die drunk. Choose life. Don't allow a drunk person to drive you. Report unsafe road usage. Call 0861 400 800. Brought to you by the Road Traffic Management Corporation and the Department of Transport.
This is a notice to all employers who are registered with the Compensation Fund. The 2015 Return of Earnings submission deadline has been extended to 31 May 2016. The Return of Earnings website for submissions will be opened on the 1st of April 2016. For more information, go to your nearest Labour Centre or Provincial Office or call 0860 105 350. The Compensation Fund, working for you.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
Right, so now we have a couple of emails, as I mentioned. The first is from Cinder, who says, I'm an indirect heir, the deceased estate of the late, and he gives a name. I'm not going to start putting out all the names, who died on the 4th of February 1994. It's been registered with the Master's Office, and by virtue of being one of the 2 blood descendants of a direct testimoniary heir, who was a blood daughter of the deceased and who passed away on the 16th of November 2008. So that is his connection. He was obviously connected to the daughter of the deceased. Mm-hmm. The matter is attended on my behalf, herself and my late brother's children, by my sister, who we appointed as the executor of our mother's estate. As far as I have been told, the property has been sold and the money is in the lawyer's trust account, and for the money to be distributed once the direct heirs had an account for rentals received since the old man passed on. So obviously there was some money coming in and they needed the accounts for that. If I am correct, this is the 4th year since this matter began. I recently asked about the status of the case from my sister and my cousin, who are also heirs of this estate, with no reply to date. I'm unemployed and I live in Lesotho.
Well, I think first things first is we need to investigate exactly what has happened in this case and what has been done in terms of compliance with the Master's Office requirements and what has not been done. Now, seemingly a large portion of the process has been correctly handled. Some monies were collected and stored within the attorney's trust account. It does sound a bit strange, just off the cuff, that an attorney would use their trust account to house estate funds, deceased estate funds, usually the procedure would be to open an estate banking account, which is a dedicated account only for that particular estate.
So not mingled with their other money in their trust account.
Yes, and it accrues interest to the benefit of the heirs. So if it's in a normal trust account of an attorney, the interest accrues to the Law Society. Now, I'm presuming it's not in any form of trust investment or anything like that.
Maybe this is just a misunderstanding of where the money is.
It could be.
Yeah.
But, you know, if this is all true and we take it on face value, then that's the first comment. Whoever the attorney is handling this should have opened a dedicated estate-led banking account where the interest would accrue to the benefit of the heirs. Then, if you can't get any information from the executor, or any family members who are directly dealing with the matter, then the best would be to contact the attorney directly, the one in whose trust account the funds are being held. And if that is also not sufficient, then the only recourse would really be to go to the master's office where this has been reported and to uplift the file, to check for yourself what has and hasn't been done and what still needs to be done in order to wrap this up. I mean, from 2008 to 2016, that's 8 years, not to mention the 1994 case. So this has a very, very long history, and this is definitely not a usual time frame in which these type of matters do get wrapped up. So if all else fails and these self-investigative matters do not answer the questions, get yourself an attorney to aid.
Now, the problem is he's in Lesotho and he's unemployed. So, first of all, to get to the master's office wherever this was registered is obviously going to be difficult.
Yes.
And to appoint an attorney is going to be difficult. So, what could he possibly go to the Law Society of wherever this master's office is and ask them for some assistance?
Potentially, yes. But because the person, I assume, they are not a citizen of Lesotho. If they are, that may complicate the potential for pro bono legal assistance. That's usually only available to citizens, but I stand to be corrected. So first thing would be to try and get the information, and I realize that this would be quite costly and quite a bit of a sacrifice for the listener to get to the master's office or to do this self-investigation or even to appoint an attorney. Maybe you can find someone through the Law Society's channels who's willing to take the case on, considering the challenges in the location and all these type of things.
Okay, but it's now almost the point where now you have to start doing your own investigation and
Yes,
start looking for things.
Definitely.
Right, okay, next one says, due to not complying with the Small Claims Court order, the Small Claims Court issued an order to attach properties. The sheriff complied to it and attached the debtor's properties. At a later stage of sending properties to be sold on auction, the debtor negotiated without paying a cent. The sheriff gave him his properties back, I assume. Was the procedure done in a lawful way? So that's the first part. So basically, if somebody has been not complied with the Small Claims Court order, the sheriff arrives, attaches the property, and then it was about to be sent off to be sold at auction. The debtor then negotiates, I assume, with the sheriff without paying any money and then gets all the stuff back. Not right.
No, that definitely doesn't sound right. I mean, first things first, a court order is a court order regardless of which court has issued it. And once a court order has been issued, it needs to be complied with. Now, the sheriff of the court is also an officer of the court, and he or she is obliged to follow the directions set out in the court order. The only way in which, legally speaking, someone could interfere with an auction and legitimately have the properties returned would to bring an application to court to rescind or to vary the court order, which empowers the sheriff to proceed with the auction. That would be the one way. In other words, another court order interferes with the existing one, nullifying it or delaying it or making some other order or giving some other direction. The other potential could be potentially an interpleader, but again, timing, it sounds unlikely that an interpleader is a process that you use to say, but you can't sell these properties or these items because they actually don't belong to me, they belong to this person and that person. So Those are procedurally the two main avenues which could interfere with this process legitimately.
But then it carries on to say that after that, the debtor then complied, or I assume it means agreed, to pay the sheriff 500 Rand a month since March last year, the 2015. In November, I asked the sheriff to pay me half of the amount paid. He agreed to pay me on the 9th of January 2016. On the 9th, he then postponed it to the 9th of February and again to the 9th of March. I called him today, telling him that I will come to collect my amount tomorrow. He then postponed to Friday. I asked him that will on Friday be a sure day. He replied by saying, I'm not in court. Just leave it. Just leave it, basically. Is the sheriff's procedural way of doing this correct? Basically, so the sheriff has now somehow managed to get 500 Rand a month out of the debtor, who I'm assume owes money to the listener.
Yes.
And so the sheriff is now supposed to be paying the listener 250 Rand. Where's the other 250 Rand going?
Well,
and he keeps saying, I'll pay you on the 9th of every month, and it's been going on for months now, and nothing happens.
Sure.
It's not right.
Well, firstly, there is usually an opportunity to settle the debt with the sheriff, and then, of course, the debt must be paid. The amount collected must be paid over to the person who it is owed to. So that's very important, just to note that there is a process in place, and yes, it should have been paid over to the listener by now. So my advice would be to the listener is if the sheriff is clearly not going to pay the money over, and you have reason to believe that they are still holding some funds that belong to you, to proceed reporting this person to the sheriff's board. It's a very similar structure to the Law Society. They also have disciplinary and investigative mechanisms in place. It's a free service, and I would say that would be the best way in order to try deal with this.
Okay, I do have this listener's email address, so I will actually, if you're listening, I'll email you contact details for the sheriff's board, and then you can get in touch with them and just make some inquiries.
Yes.
Probably be the best thing. We'll get back to that one in a moment, but let's get on to this one in the meantime. It says, an application was lodged to gain access to a late estate. The application was successful, but before the applicants became aware that the money was deposited in the bank account, the husband passed on. The applicants included the husband and 4 children, which the last was born was his biological child. So I'm assuming the other 3 weren't his. They were married in community of property. Approaching the bank, they were requested to get a new letter of authority since the father has also passed on. They went to the Master of the High Court to get the letter, but were unsuccessful in spite of having a will that is contained in the file, which is obviously in the application file. Please advise what recourse there is for them, because according to the Master of the High Court, only the last born is entitled to the proceeds.
Well, firstly, this is quite a confusing set of facts, but let's digest this in little portions. Firstly, I would say that it's very important to start from the beginning. In other words, to ensure that you understand the concept that there are 2 deceased estates in question here. One of the first dying, and then the husband, as it's referred to in the correspondence, being the second deceased estate. So when the master advised them to obtain a letter of authority, well, that's a letter of executorship for a smaller estate, then that means you have to go through exactly the same process you went through with the first estate to get it reported and registered and someone appointed to act as an executor. You need to do with the second one. So I think maybe there's some confusion with the will that has been obviously utilized in the first estate that has now found its way into the second estate. Now, there may be a little bit of overlap in terms of this will bequeathing or leaving some items to the husband, which must go from that estate into his estate, and from that into the hands of the descendants. So I think what the listener needs to do as a first point of call is to either approach the Law Society for some pro bono, for an attorney to be appointed on a pro bono basis, or just to directly approach an attorney of choice, or then to go to the Master's office for guidance on how exactly the process works. Make sure you get the process right. The Master will not just simply say that an application for letters of executorship or letters of authority have been unsuccessful, they would prescribe certain conditions to be met.
Well, what I can gather
example.
from this, what I'm gathering from this email is that there was the mother,
Yes.
who by all accounts had 4 children, 3 of which were hers alone, and then the one she had with her present
Yes.
husband. She then dies, and I'm assuming that all 4 children are then mentioned in her will.
Yes.
But when she dies, because they're married in community of property, the husband inherits, I would imagine, first. If these are all grown children, he would get her share of the estate.
Well, he would firstly, on her death, he would inherit 50%
That's
of
right.
the estate. And on his death, that 50% that he's already inherited is now in his estate, and that needs to devolve as per either his will.
Well, that's what I'm
or
saying. So
intestate.
possibly, if the listener is saying, according to the Master of the High Court, only the last born is entitled to the proceeds, because I'm thinking maybe the father
It's
then
intestate.
said, or the father left his entire estate to his son, because the other children, or the other, his child, the other 3 weren't his children.
It could be.
So that could be where the
could
snag is
be.
coming, that because the mother died and the father died before they'd sorted out the mother's will, everything devolved onto the husband. And then when the husband died, he'd only left it to his child. That could be why the master's
Could be.
saying,
But I think, saying that your letters application was unsuccessful, that, I mean, in the last few paragraphs or few sentences of this email, that can't be. The master will at most say, thank you, I received your application for this letter and to appoint this particular person as executor or master's representative. However, I need this and this and this condition to be met, or I need a security provision, or whatever the case may be. So it won't just be flat out refused. There will be some requirement that needs to be met in order for the person to be appointed. So I think procedurally, they just need to get some advice to make sure that they fill in the correct documents and that they followed the process, which they can either get through an attorney or through pro bono structures or directly at the master's office. But seemingly that hasn't been very helpful. So maybe option 1 and 2. Once that has been done, then start with the process and see why you say that only the last born will inherit. Is it because there is no will in terms of the father or the husband's estate? Is it intestate? Then it can very well be true. And then we need to also look at the will that the mother or the wife had left and what provisions there were in there. Did it go to all 4 kids? In that case, all 4 will equally share in the 50% of her estate that she retained. So one will need to see what the will provided for.
if there was a will.
If there was a will, if that also is intestate, then of course it would have been divided. The mother's portion would have been divided equally between the 4 and the husband.
Yes.
So then you'll have to compute the child share and all of that. So the easiest is actually to get someone to make a copy of what is currently with the master to see was the process followed. If not, what needs to be done in order to remedy that? And then thirdly, to explain to all the heirs involved how the technicalities would work once we've passed all the processes, all the procedural elements.
Right, okay. Now we have another question here from Kamal. And Kamal, you did say, excuse me, specifically to ask Nicolene to advise on the following, but this is a criminal matter.
Yeah.
And it's not something that you're really that comfortable with, but you'd like to
No.
comment anyway.
I'll give some generalized advice based on theory that was obtained many moons ago. So I'm definitely open to any expert coming in at a later stage. Maybe one of your other guests on the show, Karen, can comment on that and give some more practical guidelines. So mine will only be focused on a very brief, generalized comment, which is the difference between formal and informal bail applications and being formally and informally charged as the listeners outlined in their email to us. So in simple terms, an informal bail application usually takes place at the police station after the arrest has been made, and it's purely called or sometimes called informal because it doesn't take place in a court and as in front of a magistrate and all of that. And it's usually a much more informal process and is could happen or be proceeded with or without representation. Then, of course, the formal portion is the ones that we always hear on the news, bail applications being formally made in the presence of a judge or a magistrate, and that is then with representation usually, or if the accused so chooses not to.
Right, before we get on to our first caller, we have had another caller, and I think this also could be something that I'm not sure if you want to deal with something on separation of powers with the NPA and the government and courts, and not your thing. No, okay, that is way too. It's sort of falling more into the criminal side. So
Yeah.
we'll leave that for William Booth when he comes back next time.
And of course, if he can also comment on these
I'll keep this
on
for
the
Kamal.
bail,
Yes.
and the more practical side of things, being the mention of being informally charged, I think that is very misleading. You're either charged
Or
with a
you're not.
crime or you're not, and a docket is either opened or it's not. The only informal portion of the process is the bail hearing, which could either for a relatively minor offence usually happens at the police station, and it's a practical measure to relieve the courts from pressure, or it's done at the next available opportunity in the presence of a magistrate formally.
Now, William will be on the show next week, but not taking calls because we're taking the evening off. It's a public holiday. So William and I have recorded a very interesting show all about forensics and crime scenes and all sorts of things. So tune in for that. Very informative. I learnt a lot. And so tune in for that. But he won't be taking calls, but he will be back quite soon in the next couple of weeks, I would imagine, to come and do a phone-in with you. So I'll keep all these questions and we'll deal with them when William is back. Right, let's start taking some calls. If you have any questions, 0892 10 2010, 0892 10 2010. Claudia in the Overberg, good evening.
Good evening. Hello.
Hello there. You've got a question about gym membership.
That as well, but I have another quick question before that, please.
Sure.
Is a C&A will legitimate?
I beg your pardon, is a what?
These C&A, these
Oh, the
will
C&A
design
will.
C&A?
Sorry, Nicolene's just having a little bit of a panic attack, but I'll ask her. She doesn't like them from what I remember. Nicolene?
The problem with a will or a template that you acquire, whether you acquire it from whichever news agency of choice, it really doesn't matter, is that the guidelines in order to complete the document is often widely misunderstood. It doesn't always cater for your needs, which means people start filling in portions of their wishes below the lines we're supposed to sign and all sorts of things which actually invalidate the document or make it a challenging document to work with. Statistically, those are the wills that, from some statistics that were informally published by the Master's Office a couple of years ago, are those that are actually the most rejected as being invalid by them. So
They actually produce them?
No, the Master's Office doesn't produce them.
No, and you said that they produced wills a couple of years ago.
No, they produced stats.
Oh, the stats.
Statistics,
okay.
yes.
That they were the ones that they rejected the most often.
Yes.
Were these,
Because the people are not completing them correctly, or you've got too much that you want to say and you start filling in requests on the back portion of the paperwork below where you've signed and all of that, and it makes it really challenging.
Okay.
all right.
So I wouldn't recommend it. Rather spend a little bit of money and get it done professionally. Most people that get it done professionally do revisions on their wills maybe once every 2 years, and the cost saving concerned isn't worth the risk and the trauma for those that are left behind if it's not done properly.
Okay, thank you.
Mm-hmm.
Right.
Then I am a member of a gym, and I'm on stop order. Okay,
Yes.
the gym changed membership, and it was fine.
Okay.
Then they changed their computer system, and my stop order stopped.
Okay.
Okay, I did not notice this for a while. I did nothing, and then they did nothing. Now they've handed me over to a debt collector. Do I need to pay? And if so, do I need to pay with interest?
Have you used the gym facility?
Once in this time.
Okay.
And then they told me I owe them money. But not
Okay.
to worry, they will contact me.
Okay.
And then they hadn't, and I never went back.
So have you received any letters of demand or
No.
any SMSs asking you to pay or
Nothing. I
emails
just
or whatever?
received a phone call from the debt collectors.
Okay. Well, you know, it's really, I don't know what amount is involved, but if it's not a substantial amount, I wouldn't, you know, you need to look at this from a practical perspective, and, you know, for the repercussions that could have on a longer term. If you are listed as a bad payer on a credit bureau.
Not at all. No. First time.
But I'm saying they may actually do that. In other words, you know, they've already referred it to a debt collector. They don't even have to get a judgment against you. They can just go and list you as a bad payer on your credit record, and that stays there for 2 years. So if you want to get any credit or whatnot, it will actually preclude you from being able to do that.
Right.
So if we're talking about 1,000 or 2,000 rand or something like that, then you need to weigh up your ability to be able to transact versus that.
Okay.
That's just a bit of practical advice. If you are dissatisfied with their service, have you tried to maybe report this to management or to look at whichever structures they have in place to deal with this?
Not yet.
I think you need to also explore that. And then if that fails, give it a reasonable time, then you can always report it to the Consumer Commission.
But now with the fact that they haven't notified her, there's been no contact, it was their mistake.
Now, of course.
And now they suddenly sort of set the debt collectors on her. Does she not have a case here?
Of course, it's poor client service, if nothing else. But usually we sign contracts when we sign gym membership or any membership really. And particularly with a stop order, we don't really look at all the fine print. So I'm willing to bet on it that there's something in the fine print about if they don't collect the money via debit order, it's your responsibility to ensure that it was collected. And if it wasn't, they reserve the right to issue, process, blah, blah, blah. So I would recommend that, you know, you can either get some legal advice and probably spend in excess of what they are claiming from you, or you can look into raising your dissatisfaction with them directly, escalate it right through to management if needs be, and if that fails, report them to the Consumer Commission. But ensure that they haven't listed you as a bad payer. With a judgment that gets listed on your credit record, it's fairly simple to resolve, but those bad payer listings are very challenging if you don't agree with the fact that you are being labeled as a bad payer for something that wasn't your fault. This is a classic example, so be very careful that they don't do that. It will be an absolute nightmare, simply put, for you to get that resolved.
Excellent. Well, thank you very much for your advice.
Thanks, Claudia.
Good night.
Thanks.
Bye.
Bye-bye. Good night. Right, off to Dundee. Fakele, good evening. Fakele?
Good evening.
Oh, hello, there you are. Good evening. Fine, thanks, and you?
I'm good, and thanks for the opportunity.
Pleasure. How can we help you?
My question is business related. I'm a distributor for a certain company, and we had a business arrangement that they supply me the products for the whole week, and I pay them on that certain day. So unfortunately, it happened that we had an armed robbery where we were held at gunpoint alongside with my workers, and we were robbed of cash and other personal goods. So the company called me. They requested for a case number and for me to tell them what happened and explain everything. So now the problem is that they are demanding money from me weekly to pay back that loss that was suffered on that day. So they're demanding money from me, money I'm not even making on profit due to expenses and wages of workers. So in that situation, what do I do? Because it wasn't my fault, and we called the police, and everything was just luck was not on our side, actually.
Sorry to hear that, Fakele. It doesn't sound like a really good experience at all. What
No,
can he do?
definitely. Do you have an agreement with these guys that is in writing?
No, we don't have a contract, because what happened was that my dad has the contract with these people. So when my dad bought a certain route to distribute, he gave me that route. So I'm actually like using his name in the company. So we don't have a written agreement, me and the car company.
So you're almost subcontracting to your father, but your father's got the contract with them.
Yes, and my father is also demanding that cash from me. And when I try and explain that you know, it wasn't my fault that I got robbed. It happened. It's something that happens to everyone in South Africa. And here's a case number to prove that. Here are the statements of my workers to prove that. So, and since you called me and you told me to give you the case number, I gave you the case number. You told me you're gonna draft a letter explaining what actually happened since the cash got lost, what the events that occurred, what happened, and how much am I owing the company, and here's the case number. And when I request for that letter, because they said I have to sign that letter, they don't want to give me that letter now. They say it's not necessary.
Now, this definitely doesn't sound usual. What companies usually do that use distribution agents, whether it's it's usually a formal arrangement governed by a contract that the person doing the distribution has actually signed. It's very unfortunate that you don't have paperwork. So, if nothing else, ensure that in future you rather record all your business dealings or your potential arrangements in writing, that it's in a contract from the start. But other than that, usually these companies that distribute products would have insurance in place, so that if any of their distributors or anyone like that went through something like this, that you would be covered and that they wouldn't have to claim it against the distributor. Now, besides, usually there's an insurance provision. So I would ask the question, if I were you, whether or not there is insurance, and because that's why they would want a case number. Insurance always wants that, and to find out why they haven't claimed this from their insurance, if they have any. Maybe they're claiming against the insurance and they're claiming against you, which is not allowed. You must choose one or the other. And obviously a big insurance company is much easier to get this kind of money from than a private person. So that's the first question I would ask if I was you. Is the insurance? If not, why not? Surely that's negligence. And then secondly, they can't claim the repayment of this from you if you didn't do anything to contribute to the risk, So simply put, if you weren't negligent, in other words, that in the middle of the night you went to the warehouse and you forgot to lock the door and some thugs came in and an armed robbery took place, then of course if you left the door open, there's some negligence on your part. So if they can't prove any of that, then I can't see how they want to claim this back from you.
But what does he do now? Because obviously he's caught in a rock and a hard place here now. So what other course does he have other than going to the company and asking, do you have insurance? Which I'm sure they're not going to say they do. But what is his other, illegally, what can he do?
Get an attorney. That's particularly because it involves family also. It's a very unfortunate situation. The best thing would be is to get an attorney involved. They know which calls to make to ascertain also if the company did have insurance, write to some insurance companies, find out if any claims were made, that sort of thing. And then, of course, if they are to launch any further proceedings, then you've got someone that can defend it for you. So legally, the only thing that you can do now is to get yourself some representation, or wait until they issue a summons and then get yourself some representation.
I hear you, ma'am, because really right now I'm really feeling harassed, and because the representative is calling me daily, and he is very rude to me, and I've been asking him repeatedly, why did he take the case number? Because I actually asked him, because these car companies have insurances on every load that they
there you go.
And I bought that from somebody who works from there. So I don't know what to do anymore, because it wasn't my fault, and we had to go through trauma, not me alone, including workers and my wife. So really, I don't know what to do anymore.
Oh, maybe Fakile, you're in KwaZulu-Natal. Maybe get hold of the KwaZulu-Natal Law Society and ask them if they've got any lawyers that are prepared to do this pro bono, in other words, for free, that can maybe just give you some advice on what to do.
Yes.
Yes.
Or even if you just go for a consultation, pay for an hour or two and get some advice, and that they actually start digging into the facts, who we are talking about, where to start, what to look at. You know, the details that we obviously can't share on air.
Absolutely.
Yes.
But I don't think you should leave this. I think you should fight back.
Definitely. They don't have any grounds to claim this from you if you weren't negligent, inviting the risk of the robbery in. And from what you've said, it doesn't sound like any of that is your fault. So, they can't just claim that.
No,
Have you paid any money so far for Kelly?
Yes, I have actually, and
goodness.
They have told me that it's not enough. So I asked them that how much is enough, because I don't have money. I can't tell me a week to pay about 2,000 rand every week.
No, you need to go and find yourself an attorney as soon as possible, Fakile, because this is going to go on forever. They're going to keep telling you there's more and more. Can you get the money back if it's illegal? If they actually did claim this from the insurance, and you can, if they have already claimed from the insurance and you've paid them, you saying he can't get the money back?
Yes, and this if they've made him pay and misrepresented things in order to induce him to pay, then that is fraud. Classic fraud, misrepresentation, intimidation. There's a strong criminal element in it. So really, instead of paying them a cent more, rather take some money and seek some counsel.
Okay, for Kelly.
Okay, no, thank you very much.
Let us know what happens. Yeah.
Enjoy the balance of the evening.
Thank you. Good night. Bye bye.
Bye bye. Good luck.
Terrible when people take advantage of other people like that. I hate that.
Oh, goodness, and obviously they've been very traumatized. So
exactly.
And if it's family also, then of course there's a strong element of just for peace sake, let me just do this.
Yes, which isn't also right. Right, Tebogo in Langebaan, good evening.
Hey Karen, how are you?
I'm fine, how are you?
I'm fine, thank you for taking my call.
Pleasure, how can we help you?
I hope I'll be able to narrate this in a very clear way. What happens here is that 2004, my mother passed away, and then the year after that, my father passed away. I was about 22, and I had two siblings, a 13-year-old and 18 years by then. And then the master eventually appointed one of the lawyers around our area in Tabanchu to be an executor, I guess. He collected all the money and whatever that was in the estate of my father, and distributed to my two siblings. I just want to find out first question, was there a reason why I was not included in that when the distribution was made? The second one is that, remember this happened in 2005. Mm-hmm. I asked him also in the process of collecting all those assets, that so I made him aware of the house that we have in Tabanchu. Mm-hmm. And my father also had another house in one area around us in Botshabelo. Mm-hmm. And then I just found... Yeah?
Yeah, we're listening.
Yes.
Okay. And then I found out after the distribution of money, he stopped communicating with us. But then I called him after, say, for example, around 2006, back then, made him aware of the house in Botshabelo that he needs to be changed to at least one of our three siblings' names. And then I found out recently that none of those has been, and it's been a long time now. The house in Tabanchu is still not under any of our names. and not even the one in Botshabelo also is not even in any of our names. It's concerning. I mean, looking to the time frame at the moment, is there anything that can be probably ask him to continue with the whole process of transferring the house in Tabanchu and the house in Botshabelo into any of our names?
Well, firstly, I mean, you can always reopen any estate. In terms of if there's an expiry date. Luckily, it's not been someone who has actually emptied out bank accounts and wasn't supposed to be appointed as an executor and ran away with the money. Luckily, the houses are still standing, and if you reopen the estate, then you could easily have this resolved fairly easily.
Okay.
I wouldn't recommend necessarily that you go back to the same person. By the sounds, well, firstly, practicalities here. 10 years has passed since 2006. Yeah. So the likelihood, if that person was fairly elderly already or senior in practice, let me put it that way maybe, then you probably, they may not even be an attorney anymore. They may be retired by now. And by now, attorneys only keep files between 5 and 7 years, depending on the type of file that it is. So they would have likely destroyed all the records that they would have had for your case. So it would be better, in my view, to actually appoint a fresh set of eyes that can reopen this for you. And obviously, because of the area in Bloemfontein, which is where the Master's office is situated in the Free State. So get someone who's fairly close to the Master's office and who you can then instruct. I assume you are in Langebaan here in Cape Town surrounds.
Yes, I'm based in Langebaan now.
But now you also mentioned why he was left out in the first place.
Yeah, we'll get to that in a minute. So I think maybe appoint an attorney in over here who you can easily access and go and see and meet them face to face, and they in turn can get someone to act as, we call it a correspondent or a post box. In other words, they can go to and get the physical records. We've got a network between attorneys to be able to do that. But always pick someone that you can actually go and see, physically walk into their office. You can see if this is a person that you would like to work with and so on. As for being left out of the estate, there's no legal reason unless there was a will that provided for the maintenance of the minors.
No, there was no will.
Oh, there was no will, then he should have got something.
Then you should have, all the children benefit equally, and usually the minors, their shares or share of the estate is paid into the Guardians Fund, which then gives them a monthly payout to pay for things like school fees and so forth. Or when they become of age, then they get their portion. So from a legal perspective, there's no reason for being left out.
Okay. I don't know if there was elements of negligence there, because, I mean, like I said, my younger sister was about 13 years, and my younger brother was about 17. So they are 4 years apart, but that means he was 17 by then. The whole money was just given directly to them into their bank account. And
oh, goodness,
just imagine a 13-year-old with a lot of money in the bank account. What would they do with that?
That sounds like negligence to me.
Yeah, to me, I think you need to get a fresh set of eyes on this, reopen the estate to deal with the properties, and let them look into who got what and how it was paid and so on, to ensure that, if there was negligence, that you can pick it up. And so unfortunately, so much time has lapsed. I don't know if you'll be able to claim against.
It's been quite a long time.
Yeah, you won't be able to claim against.
But at least you can do something about those houses. You can do that properly.
Yeah, at least you can get that done, and that you can do through any conveyancer. I mean, it doesn't need to be an attorney only specializing in estates. It would help if they've got some knowledge of estates. But any person who deals with property transfers can help you with this.
Okay. All right, then.
Good luck, Tebogo.
Goodness, good luck.
All right, good night to you. Right, off to Verulam now. Parimal, good evening.
Good evening, Karen, to you and the conveyancer. My question is, look, I have a property for sale. I haven't sold it yet, but I'm going to give it to the estate agent. I was informed that the VAT that you pay to the SARS will be paid by the agent, from the commission they get from me. Is that true?
Well, I think we must just take one step back quickly. A transaction for the sale of a property can either be you either pay transfer duty, and that's usually something the purchaser pays. In other words, the person buying from you as the seller.
Correct.
Or if you are in the business of buying and selling property, like a property developer, for example, then you won't pay transfer duty, but you'll pay VAT. Okay, so that's just the one point I want to make.
Right.
Most estate agencies that are fairly large, I mean, think of all the big names out there, are registered VAT vendors because it's in their line of business to buy and to facilitate the buying and selling of property. So when you pay the agent's commission over, actually the conveyancer does that, practically speaking.
Right.
When they do that, yes, that portion includes VAT. And when the agency files their VAT return every second month, they then pay that over to SARS.
But they can't charge you extra on their commission. If they have a commission, say, of 5% or whatever they take, I don't know what they do.
Usually the accounts say...
But part of that 5% includes the VAT. You can't say, well, here's 5% and then I'm also charging you extra however much for VAT.
It depends what your deed of sale that you've signed
so
says.
Just be careful what you're
and
signing.
It also depends if you've given a sole mandate to an agent, what that says. So before you sign an offer, you must check if it says VAT inclusive. So I've worked with quite a few agencies where their price is VAT inclusive. And similarly, I've worked with equally as many who say so-and-so % plus VAT. So you must just read quite carefully, yes.
Yeah. So in other words, if the VAT is included in the commission, then it does not come out of the seller's pocket. The agent will pay it out of the commission.
Yes, yeah.
Provided that is in the agreement.
Yes. Just check the contract very carefully before signing.
Thank you very much. You have cleared my doubt, and I feel happy about that. Good night.
Thanks, Parimal. Good night to you. Bye-bye.
Good luck. Good night.
Right, this is going to be one of those, oh my goodness, stories. Finangela in Soweto, good evening.
Good evening, ladies. Hello, Karen.
Hello. I'm very concerned about your estate here. 21 years.
Yes, I phoned you in in October 2014 about a lawyer who will not wind up my mother's estate. It's now 21 years. You know, there was some property that my father had in the so-called homeland. And then he said I had to get clearance certificates from there. I've been getting clearance certificates, which have a duration of about 2 months. And then he makes them lapse. And then I go to find out what he has done. He tells me that, oh no, those have lapsed. You've got to go to others. And, go and get new clearance certificates for them. It's like farms, 10 Morgan each. There's 3 of them, 10 Morgan each. I've been getting them from the homeland, taking them to his office. But now of late, the latest one I gave to him on the 29th of January. And I asked him, I've been doing the follow-up every week, what he has done. He tells me that, he sent those to the master's office, but now the plot numbers have been changed. Now he's got to get the new plot numbers, and I must wait for him to get the new plot numbers. But the time is running out. The next thing he'll be telling me that, they have expired. I don't know what to do anymore. And in the liquidation account, there were monies that my father invested in the building societies, and SAFM. So I went to Nedbank because I know that PEM was part of Nedbank. They said I must get a letter of authority from a magistrate's office so that they can go into their archives, to look for these. Okay, I'm not very well. I sent my younger brother, but he hasn't been able to do this. I just don't know anymore. My father had properties. He won't give those to us. Those were in the townships in Natal. He doesn't want to give them to us. We are 3 siblings. I don't know what to do. I have got another lawyer, to speak to him. He tells me that he wrote him an email and he still hasn't replied. The lawyer that's handling the estate hasn't replied to the lawyer that I asked to help us out. I don't know what to do.
Finangela, I'm almost on the point of saying, well, can't you just let the lawyer lapse and get a new lawyer? Because this one doesn't sound like he's doing a proper job here.
Yeah.
What can she do? I mean, this sounds ridiculous.
And in fact, I was going to take a much harsher approach than you. Say, report this guy, or I assume it's a guy, report this attorney to the Law Society for disciplinary investigation and hearing. I mean, this is unprofessional, to say the least. And of course, claim every single clearance certificate that you've had to pay for and obtain, is together with any travel costs. claim this back from this attorney. So when you complain at the Law Society, it's the Law Society of the Northern Provinces, I assume, where the state or where the attorney is based.
Where is he, Philangeli? Is he in Johannesburg?
In Johannesburg, Highlands North, in Johannesburg, Highlands North. In a suburb called Highlands North in Johannesburg.
Philangeli, do you have an email address?
No, unfortunately, I don't.
Okay, I've got your phone number, because what I was going to say is I could just give you the contact details for the Law Society of the Northern Provinces, but what I will do is I'll SMS it to you.
Okay, I appreciate that very much. But I did tell you when I phoned you in October 2014 that I had written to the Law Society in 2012 or 2013, thereabouts, complaining about this estate not being wound up. And they replied me and said, oh, no, nothing has prescribed, There's nothing that they can do because it has prescribed.
But surely, I understand if you're claiming money from the attorney, that, you have 3 years to claim whatever you feel damage this person has caused. But for unprofessional behavior that is seemingly continuing as we speak, I would actually institute a complaint for unprofessional behavior, simply put. So that can't prescribe. If you are being unprofessional, or if you are breaching the code of conduct or the code of ethics laid down for attorneys, that never lapses. It's like a criminal charge. You can be charged years after you committed a crime. So same theory behind it. So first things first, report this person, get a replacement attorney to take over, and whoever replaces this person needs to take a much firmer approach. You've tried asking, you've tried being nice, you have to get this person removed from this estate and appoint someone who's competent and professional who can actually deal with this. And if they need to take this attorney to court to force him or her to hand over whatever belongs to you and to pay some monies, at least so that you you haven't just lost everything in terms of what you've spent, then so be it.
Also, I must get another lawyer.
Get another attorney, and they must deal with that one much more harshly. Not just write an email that doesn't get responded to, and okay, what do we do now? Someone who says, okay, you respond within a week to my email, or I will report you to the Law Society, my dear colleague. And if that also doesn't help, I will get a court order to collect all the documents pertaining to this estate from your office. And if we need to do that, we need to do that. But this person needs to be removed from this case. This has gone on
no more being nice anymore, Philangeli.
No.
You've been nice. You've been nice for too long.
For the advice. Thank you.
So basically, because you said you had another attorney, but he just emailed this other one.
Yes, he emailed this one, and then he says he doesn't get a reply from me. When I asked him what he said, he told me he actually sent. I asked him to send the email to my daughter, because my daughter has an email, but we don't stay together. She's got her own house. So she told me the email that this new lawyer, sent to this lawyer that's handling the estate. But then the one that's handling the estate never replied to the one that sent the email.
Give him a deadline, and if he doesn't respond, report to the Law Society. And if you have to forcefully remove him from dealing with this estate further, and you need to go to court to do that, do that. I mean, 21 years is a very long time. This is absolutely ridiculous.
And in Philangeli, as Nicolene said, make a list of all the money you've spent, all the travel you've had to make, the transport costs you've had to pay out, all the money you've spent getting all those documentations about the property, all that money that you've spent. Make a list. And then you can also try and claim that money back from him, because he's cost you all this money because he's been inefficient.
Yeah, sure.
Yes.
Unprofessional.
Thank you very much for this advice. I've got the list of all the monies, because I was even asking my siblings to help me out. But, they were quite lax about it. So I had to spend my own money to go and spend. But the last one, my elder brother actually did help me to pay, because it was over 1,000, the money that we had to pay them.
That's ridiculous.
At this homeland, to get the clearance certificates.
If you need to get this guy removed from dealing with the estate and handing over all the paperwork in his possession, then do that. That would be my advice to you. No more asking nicely or what the case may be. Enough is enough. Get someone who's willing to remove this person from dealing with this case and to get them dealt with through our professional structures.
Thank you very much. I'll speak to my siblings and then we'll decide which they are to get to remove this. And
the other thing, I believe you're phoning in on a landline, so I can't SMS you on that. Can I put you...
I've got it, just that I haven't got airtime on... I've got a cell phone, but I haven't got airtime on it. Can I give you
No, I'm going to put you back to my producer now. I'm going to put you back to my producer and give him the number. I don't want you to give out your number on the air because everybody will start phoning you then. So I'm going to put you back to him and just give him the number and then I'll SMS you that information.
Thank you very much.
Thanks, Philangele. Have a good evening.
Lady. Thank you.
Thank you, Nicoline. Bye-bye. Right, and Stanley in Springs called in and he wants to talk about child maintenance, but unfortunately we literally have a minute to go to the end of the show. But Stanley, we will keep your name and number because we are going to be doing family law in about the next 3 or 4 weeks. So what we'll do is we will keep your number and we will call you that evening. And you can speak to our attorney that's going to be talking about family law and including which will be child maintenance. Right, so you've had all the advice from Nicoline. A number of callers. Don't let people push you about if they're in the wrong. We've had 2 of those tonight, so
definitely
fight back, as I said, and don't take it.
Definitely.
Right. Well, my thanks once again this evening to Nicoline Skumanlo. She's a director of Skuman Law Inc., attorneys, conveyances and notaries public, practicing here in Cape Town, and she's been my guest on tonight's edition of the Law Report program. And Nicoline won't be back with us on the 11th of April, but who will be with us on the 11th of April?
Anja Jansen van Rensburg from our office will be joining you. I'm traveling a little bit, but I'll see you then in May again.
Yes, so we'll still be doing our law clinic next month. Law Report every Monday between 9 and 10. Next week's program, I'll be joined in studio by criminal law attorney William Booth. We won't be taking any calls, but we will be taking a look at forensics. That's the Law Report next Monday, the 21st of March. And I'll be back again tomorrow just after 9 with health matters, so join me then. It's time now for some nighttime music. Hello, Stephen.